All right, we've got another guest joining us this hour. Anahita Sedaghatfar is joining us from LA today. Anahita, great to have you aboard today. Thanks so much for being here. Let me ask you about eyewitness testimony, because I think this is an important issue. Whether or not that towel was there or not there at the time that this EMT responded to the death scene. Okay? Again, it seems what prosecutors are trying to allude to here is that sometime between the EMT responding and the crime scene photos or the death scene photos being taken, the towel was placed on that bathtub. The EMT says, I didn't see it. I came there was no towel there, and I see a picture now of the towel, but that towel wasn't there. How reliable? This is March 1st, 2004. How reliable do you believe this type of testimony is? How compelling is it?
Right, and that's definitely something for the jurors to decide. We're talking about testimony that someone is giving today about something he may or may not have seen years and years and years ago. And that is exactly what I think the defense is going to need to bring out on cross-examination in terms of impeaching this witness. What else does he remember? Are they going to be able to find other inconsistencies, things he may have told the police that he doesn't remember today on the stand? I mean, I think jurors like to hear eyewitness testimony. It's much more reliable than hearsay. But here we're talking about something that happened so many years ago, and something like a bath towel. I mean, that's definitely something the jurors are going to have to decide in terms of reliability and credibility of the witness here.
Absolutely. And here's the thing, and let me go back to Beth Karras. Beth, did this witness testify that how long before the witness gave up this bath towel? I mean, did he just say it today on the stand for the first time, or was this brought out early on in the investigation? Early on, did he tell investigators, hey, there was no bath towel there?
No, yeah, he told it early on. He said he spoke to the state police within 3 or 6 days because they were continuing the investigation, and he told them that he thought it was weird. That was objected to, but it was overruled, and he continued. So he did bring it to their attention within a few days. All
right, so I think that's important. Let's Anahita, how about that? How about you've got a witness now, you know, within days, saying, you know what, that was strange, because I responded to this death scene in this bathtub and there was no bath mat and there was no bath towel there. To me, that's strange. Do you find it more credible?
It certainly is more credible, but how many inferences does the prosecution want the jurors to make in this situation? Okay, so there wasn't a bath towel at the time the EMT was there, but there was later on in a photo. What's the inference there? Is the inference somehow that Drew Peterson...
Yes!
Yeah, exactly.
That Drew Peterson, the cop, staged the scene to make it look like an accident. That's the inference.
Exactly, and that's a pretty large leap to make. I mean, look, you have EMTs, you presumably have the investigators, the state police department there, and Drew Peterson somehow is able to think at that moment, let me go grab a bath towel and make this look staged. It just seems implausible. But again, that's something that the jurors are going to have to decide, whether or not Drew Peterson actually planned and plotted this all around a towel. To me, it seems a little far-fetched, but I mean, if that's where the prosecution wants to go with it, that's where they're going to go, and the jurors are going to ultimately decide whether or not that's an inference they're willing to make.
Judge Anahita thinks this is a huge leap for prosecutors to try to make and tell a jury to go from the point of no towel to Drew Peterson staging a scene to make a murder look like an accident. Do you think, how big of a leap is it? Let's say 10 is a leap over the Grand Canyon. And how far of a leap do you think this is? 0 to 10.
Well, first of all, they have to believe this particular...
That may be what the state's going to say, is he picked the lock. Actually, there had been argument pre-trial, you may remember it too, where the defense had said, there's no evidence that he picked the lock. You can't just say he picked a lock when there's no evidence of it, but I think they may argue that as well. Or instead.
Anahita Sedaghatfar is also with us. Anahita, this is another big obstacle for prosecutors. You've got to give this jury a way for Drew Peterson to gain access to his home, but it seems to me the jury should have the full picture, right?
Yeah, the jury should have the full picture. I absolutely agree with that. But once again, we're talking about quantum leaps.
Wait, this one's a we got to define. This is going to be a quantum leap for him to use his garage door opener and then the hole in the wall, or pick the lock. Cops know how to pick locks, don't they, Anahita? Come on.
Right. No, you're right about that, but let me explain why. So presumably the prosecution will have the jurors believe that Drew Peterson somehow, got into the house through this hole in the wall, placed towels when towels didn't exist when the EMTs arrived, but there's no DNA evidence. There was a thorough investigation conducted by the prosecution's own people. The state police did a thorough investigation. Where's the DNA? Where are the fingerprints? Where is there any evidence that Drew Peterson was in the house at the time Kathleen Savio was murdered?
Well, there's no.
I believe
they haven't been able to get any evidence about Stacey Peterson either. Do you think she ran away? Well, let me do this. We've got Gene Casares on the.
There when you did get in, you could argue that either way.
Yeah, Anahita, how about that? Do you find any of this troubling for the defense, that people might look at this situation, just the manner that Drew Peterson orchestrated what happened? And he was orchestrating what happened that night, and depending on your point of view, he's either orchestrating the discovery of his wife who tragically accidentally died, or is orchestrating the cover-up of his murder. Either way, do you find it suspicious, all the little things that he did that night to gain access to the house?
I actually agree with the judge. I think he made very valid points here. You've got to remember, Drew Peterson was going through a very contentious divorce. And according to him, Kathleen Savio was making up many, many lies about him. She made up lies, according to Drew Peterson, in order to obtain a restraining order or attempt to get a restraining order against him. In his mind, she was trying to build a case against him. So how else would someone like him act? Would it be prudent of him to go in there by himself, break in, somehow get in by himself? I don't think so. I think at that moment he did what he felt he needed to do to protect himself in case there was something wrong. So, how are we to say how someone in that situation is supposed to act? And he is the police. So who was he going to call? His colleagues to come? I mean, I think at that time, not knowing what was going on, not knowing what he was going to find in there, he acted prudently.
This is the point where I see both sides of the story, but I'm a little concerned that it just worked out a little too conveniently, that all these other civilian witnesses were there and making the discovery and not him. But, you're going through a contentious divorce, and, you're battling over custody, you're battling over money and everything else. Maybe it is the prudent way, but it's going to be up to the jury to try to figure out if this is suspicious at all, or if this is just him being smart going through a very contentious divorce. Big thank you to the Honorable Stephen White, Judge Stephen White. Great to have you on our air, Judge. Appreciate all your insight into this. Thank you so much. Anahita, thank you
very much.
Anahita, thank you as well. And Beth Karras, our correspondent, standing by. We thank you.